Hi, it's Mike DelSignore. I want to talk about a recent win we had in Chelsea court. This was a case where our client is not a citizen, saw us for a second offense OUI, but had a prior offense in Chelsea District Court. We were able to vacate that plea based on some problems with the breath test, making them a first offense client in the other court. So essentially, and I've done this a lot, what happens is if there's a breathalyzer, you took a breathalyzer between 2011 2019, you could potentially have a motion for a new trial to reopen that case. Why is that important? It changes the license loss. If you refused on your second offense, it reduces the 3-year license loss to 180 days. So it makes a significant difference, even if you were later found guilty for the first offense, because they could still prosecute that. I've had many clients have success. I had cases in Taunton, Wareham, Attleboro, West Roxbury. Recently, we had one in Barnstable, arrested by the Hyannis police, where all these prior OUIs, people that came to us with second, third offense OUIs, had it knocked down one level. And usually the case gets dismissed, the one we vacate. This is certainly crucial for anybody, but if you're not a citizen, it can even be more important because it could lessen the immigration impact. So, what should you do? If you're charged with a second or third offense, always review the prior offenses, especially if there's a breathalyzer between 2011 and 2019 for a motion. It's called a motion to vacate. I've done these many times with a high degree of success. So what I had to do is look at the old case and then try to I didn't represent the client on the original case. I had to contact the lawyer, prepare an affidavit for him, basically saying that had he known about the breathalyzer, he wouldn't have recommended a plea. Then I do an affidavit reviewing the case saying this looked like a good case for trial, but for the breathalyzer. And so I prepared an affidavit based on the report, how I think the testimony would come out. So it's essentially I was creating my argument as I would anticipate the officer would testify, saying to the judge, look, these parts of the report, the officer probably would have acknowledged they weren't signs of impairment. I said in my affidavit that, often the trial testimony is better, comes out better than the report. So let's not overvalue the report because witnesses testify differently in court than what's written on paper. And then I reviewed the rest of the report to basically find areas where we could show reasonable doubt. And then in the affidavit, my conclusion was, based on this was a good case for trial. It could have gone either way, and that's why I argued in front of the judge. Certainly wasn't a guarantee not guilty, but there was a reasonable probability. That's the standard we have to show that the defendant would have prevailed at trial. This wasn't an overwhelming case. And I argued to the judge, the Massachusetts Supreme Court, set up a very low standard for having these motions allowed. In the court decision, they didn't really go into much detail. They basically said, well, the plea wasn't really, they said the plea wasn't so beneficial. In other words, the person got the standard disposition. They said there was an affidavit from counsel saying usually breath test cases aren't particularly strong and that they make for good cases. So the original case, the affidavit of the lawyer really didn't go into a ton of detail. So, and the court didn't require it. They didn't say, well, you needed more detail. They basically accepted the affidavit at face value and said that the standard was met. So it's a low bar. Most of these motions should be allowed, and they can be crucial. So if you're charged with an OUI, if you have a second, third offense, make sure you look into these prior convictions. So the case we had was in Chelsea District Court. I represent people charged with OUI all over Massachusetts. A lot of people in courts like Chelsea sometimes have immigration issues. With President Trump now, immigration issues, you definitely want to fight an OUI case if you're charged because the laws can change. He could change the immigration consequences. So hire a lawyer. We do this every day. We're in courts fighting for people on OUI cases. So feel free to reach out. Be glad to represent you. Most of my clients have been with me for years. Hopefully you won't get another offense, but I've had clients recommend other clients, and clients who have had the misfortune of picking up a new OUI have often come back. So I love what I do, and I'd like to help you. Call, text anytime, 781-686-5924. Mike DelSignore, here to help you when charged with an OUI offense.